Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner.
In today's video, we are going to discuss section number 34 to 38 of Bharatiya Sakshya Adhiniyam 2023.
Alright, so today we're going to discuss Section 34 of the Bharatiya Sakshya Adhiniyam 2023. Now, this section is all about a very important principle called judicial finality. What does that mean? Well, it basically ensures that legal disputes don't just go on forever, and it helps save the court's valuable time.
So here's what the Bare Act language says, more or less. But let's break it down in simple terms, right? What it really means is this. If a court has already given a decision, a judgment, an order, or a decree on a particular matter, and because of that decision, a new case on the same matter can't be started, then that previous decision itself becomes a relevant fact. Simple as that.
Okay, to really get a grip on this section, let's break it down into three key ingredients. Think of it like a recipe. First up, you need a previous judgment. This means there has to be a final decision from a court that already exists. Got it? Good. Second, that judgment must create what we call a legal bar. This is the part that legally stops a new similar case from moving forward. And finally, number three, that previous judgment becomes a relevant fact when the court is deciding whether this new case should even be heard or not. Let's make this crystal clear with a practical example. Imagine this. A files a civil case against B over a piece of property. The court hears the whole case and finally gives a verdict in favor of B. Now, here's where Section 34 comes into play. According to its principle, A cannot just go and file another case against B for the very same property and on the very same issue. Why? Because that first judgment creates a legal bar. The court simply won't entertain the new case. This is exactly the principle of res judicata, which literally means a matter already decided. Now, there's a super important landmark case connected to this concept. It's a big one. Any guesses which case really focuses on this idea of the finality of judicial decisions? Think about it for a second. And that landmark case is Satya Dhyan Ghosal versus Darajan Devi, a Supreme Court judgment from 1960. You absolutely need to remember this one. From an exam perspective, it's incredibly important, so make sure you note it down. So, what happened in this case? Well, the Supreme Court very clearly explained this principle of the finality of judicial decisions. The court held that once an issue between two parties has been finally decided, you just can't reopen it at a later stage of the same litigation. That's it. It's done. The crucial word to remember here is finality. All right, now let's quickly see how this compares to the old law. This new Section 34 of the Bharatiya Sakshya Adhiniyam 2023, it corresponds to Section 40 of the old Indian Evidence Act 1872. So basically, what was Section 40 is now Section 34. And here's the key thing to note. There has been no substantive change. None at all. The legal principle is exactly the same, only the section number has been updated. Okay, let's get to the most important part for all of you, the exam importance. For both judiciary prelims and mains, this section is a big deal. In prelims, you could get a direct question. In mains, they might ask you to link it with the concept of res judicata. It's also good to remember the similar principle in criminal law, which is double jeopardy. You can't punish a person twice for the same crime. And for the APO exam, yes, there's a very high chance you'll see a direct question on this topic.
All right, let's do a super quick revision of everything we've learned. What's the section? Section 34 of the BSA 2023. What's the core concept? It's about the relevancy of a previous judgment that bars a new suit or trial, which we know as res judicata, or, in a similar vein, double jeopardy. And its exam importance? It's a high priority topic for both judiciary and APO exams. Got it?
For more judiciary-focused legal content just like this, make sure you stay connected with us here at Ganga Education.
आज हम डिस्कस करेंगे Section 35 of the Bharatiya Sakshya Adhiniyam 2023. This is a really important one for your exams, so let's dive right in. Alright, so when you first read this, it might seem a little heavy, right? But let's break it down. In simple terms, this section is all about a special type of court judgment. These aren't your typical judgments. We call them judgments in rem. And what makes them so special? Well, their effect isn't just on the people involved in the case. Nope. It applies to the entire world. Think of it as a final, universal declaration of someone's legal status. So, Section 35 doesn't apply everywhere. It's very specific and only covers these 4 key areas of law. You absolutely have to remember these. First, we've got probate. That's everything to do with whether a will is valid or not. Second, matrimonial jurisdiction. This covers things like marriage, divorce, and a person's marital status. Third is admiralty, which is all about maritime law and disputes at sea. And finally, number 4 is insolvency, which deals with cases where a person or a company goes bankrupt. Now, for your exams, this part is crucial. You need to know what makes a judgment fall under Section 35. It's not just any court order. It has to tick all of these boxes. It must be a final judgment. It has to come from a court that actually has the power to make that decision, a competent court. Of course, it must be related to one of those 4 jurisdictions we just talked about. And here's the real heart of it. The judgment must actually give, take away, or declare a person's legal status or character. So let's double-click on this core concept, judgment in rem. As you can see, it's a judgment that settles the legal status of a person or even a thing. And it's binding on everyone. The whole world has to accept it. For example, if a court declares a ship to be a prize of war under admiralty law, that's it. Everyone, everywhere has to recognize that fact. It's not up for debate. Let's make this super clear with a simple, practical example. Imagine a couple, let's call them A and B, go to a family court, and the court grants them a divorce. That court's final order, the divorce decree, does something very powerful. It changes their legal character from married to divorced. And this isn't just between them. This new status of being divorced is now a fact for the entire world. It's conclusive proof. No one else can come along and say, hey, I still think you're married. Okay, time for a landmark case that you absolutely have to know. It's Surinder Kumar versus Gyan Chand. In this very important case, the Supreme Court made it crystal clear. They held that a judgment given by a probate court, the court that decides if a will is valid, is a perfect example of a judgment in rem. This means once that court says a will is valid, that decision is final and binding on every single person, whether they were part of the case or not. It's a fantastic case to cite in your answers. So you might be thinking, is this a brand new idea in our law? The answer is no. This exact principle used to be in Section 41 of the Old Indian Evidence Act of 1872. As you can see from the table, there's no real change in the law itself. The core idea of judgments in rem and those 4 specific jurisdictions, they're exactly the same. All that's really changed is the section number and a bit of modern language. So if you knew Section 41, you already know Section 35. Now, let's talk about why we're spending time on this. From an exam point of view, Section 35 is a high-value target. It's extremely important for both your judiciary prelims and your mains. You can bet on getting direct questions about judgments in rem, or they might ask you to list the 4 jurisdictions. And for the APO exams, this is a recurring favorite. So please, make sure you know this section inside and out. Okay, before we wrap up, let's do a super quick revision. Just remember these 3 things. 1, we're talking about Section 35 of the Bharatiya Sakshya Adhiniyam 2023. 2, the core idea is that final judgments in probate, matrimonial, admiralty, and insolvency cases are conclusive proof against the whole world. And 3, this is a hot topic with a very high chance of appearing in your judiciary and APO exams. Got it? And that's all for our explainer on Section 35. For more judiciary-focused legal content just like this, make sure you stay connected with us here at Ganga Education.
Today, we're going to dive into a really important legal provision, one you absolutely need to have on your radar. We're talking about Section 36 of the brand new Bharatiya Sakshya Adhiniyam 2023. All right, so let's start with a question. Think about this for a second. Let's say there's a case happening right now. Is it possible to use a judgment from a totally different case, one that's already been decided in the past, as evidence in this new case? And if you can, just how powerful is it? How much weight does it actually hold? Well, this is exactly the kind of question that Section 36 helps us answer. आज हम डिस्कस करेंगे Section 36 of the Bharatiya Sakshya Adhiniyam 2023. Now, you'll want to pay very close attention here because this is a section that you can definitely expect to see in your upcoming judiciary exams. Okay, so let's get right into the text of the Bare Act itself. The section says that judgments are relevant, but only if they relate to matters of a public nature. And here's the really crucial part, the part you must remember. It says, but such judgments are not conclusive proof. So what does that actually mean? It means, yes, a court can look at that previous judgment, but it's not the end of the story. It isn't the final word. The court still has to look at all the facts and evidence in the current case and make its own independent decision. So to make this super clear, is section में 3 important चीजें हैं. First, the judgment has to be about matters of public nature. What's that? Well, think of things like a public pathway or a local custom that affects everyone. Second, if it is about a public matter, then it becomes relevant evidence. And third, and this is the most important distinction, it is not conclusive proof. It's a key piece of evidence for sure, but it doesn't automatically win the case. All right, let's make this real with a practical example, the kind you might see in an exam. So, suppose a person, let's call him A, files a lawsuit against another person, B, and the charge is trespassing on A's land.
Okay, but here's the twist. B's defense is that he wasn't trespassing because there's a public right-of-way on that land. A path that anyone from the public can legally use. And to back this up, B points to a previous court case, let's say it was A versus C, where the court actually established that this exact public right-of-way exists on that same piece of property.
So this brings us right back to our main point. What's the status of that old judgment, the A versus C one, in this new case between A and B? Well, let's look. Is it relevant? Yes, absolutely. The court can and will consider it. But, and this is the key, is it conclusive proof? The answer is no. The court hearing the new case isn't just bound by that old decision. It still has to look at everything fresh and make its own call. The big takeaway here is relevant, yes. Final, no.
And this principle isn't just in the Act, it's backed by the courts. A really important landmark case you should remember is Tirumala Tirupati Devasthanams versus K.M. Krishnaya. In this case, the Supreme Court held that judgments that deal with public rights, like pathways or customs, are definitely relevant as evidence in later cases. So this case really solidifies the idea behind Section 36.
Now, a quick point for those of you who have studied the old law. ये section पहले Indian Evidence Act of 1872 का Section 42 था. Now, it has become Section 36 of the Bharatiya Sakshya Adhiniyam 2023. It's really important to know that the substance of the law hasn't changed at all. The principle is exactly the same. The only thing that's different is the section number.
So why are we spending so much time on this? Well, let's talk about why it's so important for your exams. Judiciary prelims are mains dono ke liye section bahut important hai. For prelims, you could get a direct question on its evidentiary value. For mains, you might see a problem-based question, just like the example we just went through, and for the APO exam, a direct question on this topic is definitely possible.
Okay, let's wrap up with a very quick revision to make sure this sticks. First, we're talking about Section 36 of the BSA 2023. Second, the core concept. Judgments on public matters are relevant, but they are not conclusive proof. And third, remember its high importance for your prelims, mains, and APO exams.
I really hope that breakdown helped make Section 36 crystal clear for you. For more judiciary-focused legal content just like this, stay connected with Ganga Education.
Today, we're going to tackle a really important topic from the new evidence law. We'll be diving deep into Section 37 of the Bharatiya Sakshya Adhiniyam 2023. So here's what we've got on the agenda. We'll start with a quick intro to Section 37, then we'll break down its core ingredients. After that, we'll look at some practical applications in case law and wrap it all up with the essentials you need for your exams. Let's get started. All right, first up, Introduction to Section 37. We're going to look at the general rule of relevancy here. आज हम डिस्कस करेंगे Section 37 of the Bharatiya Sakshya Adhiniyam 2023.
Okay, so what does this actually mean? Let's break it down in simple terms. The basic idea is this. A court's decision from one case, well, you generally can't just pick it up and use it as evidence in a totally separate, unrelated case. Why? Because the court wants to look at each case fresh, based on its own specific facts and evidence, not on what happened in some other dispute.
Okay, moving on to part 2, let's understand the core ingredients. We have the main rule, but like any good legal rule, it also has some very important exceptions.
So इस section में 3 important चीजें हैं. First, the general rule. Judgments are usually irrelevant. We've covered that. Second, the first big exception, when the judgment itself becomes a fact-in issue. This means the existence of that previous judgment is a central question in the new case. And third, the second exception, if the judgment is relevant elsewhere under the Act. A classic example here would be to show someone's motive.
All right, theory is one thing, but how does this all play out in a real courtroom? Let's look at some practical illustrations straight from the Adhiniyam, and then discuss a landmark case that really cements this principle. So let's see when judgments are irrelevant. Take illustration A. A sues C for libel and wins. Now B also sues C for a totally different libel. Can B use A's victory as proof? Nope. It's irrelevant because it's a separate case. Same with illustration B. B gets convicted for stealing A's cow. Later, A sues C, who bought the cow from B, to get it back. B's criminal conviction can't be used in this civil suit. The civil court needs to decide based on its own evidence, not the criminal court's finding.
But now, let's flip it. When do judgments become relevant? This is where the exceptions kick in. In illustration C, A gets a decree for some land against B. Later, A is murdered, and B's son is on trial. That old land decree? It's now relevant because it shows a possible motive for the crime. See how that works? And in D, if someone is charged with theft and the charge specifically mentions a previous conviction, well, that previous conviction is now a fact and issue. It's central to the case, so it's absolutely relevant.
And this whole idea is backed up by a very important landmark case, KG Prem-Shankar versus the Inspector of Police. Here, the Supreme Court made it crystal clear. The court held that what's decided in a civil case isn't automatically binding in a criminal case, or the other way around. You can't just copy-paste the result. Each case stands on its own feet. A judgment from one can only be used in the other if it perfectly fits the relevancy rules we've just talked about. Okay, let's move to our final section, Exam Essentials and Summary. Now this is super important for your preparation, so pay close attention. We'll cover the old law, why this section matters, and a quick revision.
ये सेक्शन पहले इंडियन एविडेंस एक्ट 1872 में सेक्शन 43 था, जो अब रिप्लेस हो चुका है बाय द भारतीय साक्ष्य अधिनियम 2023. Now this is absolutely crucial to remember for your exams. The legal principle remains exactly the same. Nothing has changed in the substance of the law. Just the section number and a bit of modern language.
जुडिशरी, प्रीलिम्स और मेंस दोनों के लिए ये सेक्शन बहुत इंपॉर्टेंट है. एपीओ एग्जाम में इस टॉपिक पर डायरेक्ट क्वेश्चन आ सकता है.
All right, let's do a super quick revision to lock this in. 1. The section number is 37 of the Bharatiya Sakshya Adhiniyam 2023. 2. The core concept is simple. Judgments are relevant unless the judgment itself is a fact and issue or relevant under some other provision. And 3. For your exams, remember this is a crucial topic for understanding the relevancy of evidence for both prelims and mains.
For more judiciary-focused legal content, stay connected with Ganga Education.
In today's explainer, we're diving into a really critical safeguard in our justice system. We're talking about Section 38 of the Bharatiya Sakshya Adhiniyam 2023. This is the section that tells us exactly how and on what grounds a court's judgment can be challenged. So let's get right into it. So, what's our plan for today? First, we'll get a clear understanding of what Section 38 is all about. Then, we'll break it down into its key components. After that, we'll see how it works in the real world with a practical example and some landmark case law. We'll also cover why this is so important for your exams by comparing it to the old law. And finally, we'll wrap it all up with a quick revision. All right, let's jump right in. First things first, what exactly is Section 38 and which law are we talking about? आज हम डिस्कस करेंगे Section 38 of the Bharatiya Sakshya Adhiniyam 2023. Now, you might wonder why this section is so important. Well, it's because it lays down the fundamental grounds on which a court judgment, even if it's relevant, can be attacked and proven to be invalid in another case. So, what does this legal language really mean? Think of it this way. Other sections in the Act make certain judgments relevant, but Section 38 acts like a safety check. It gives any party the power to say, hold on, that judgment shouldn't be considered because it was delivered by a court that wasn't competent or it was obtained by cheating, through fraud or collusion. It ensures justice isn't misled by a tainted judgment. Okay, now for the most crucial part, especially for your exams, let's break down the exact legal grounds you can use to challenge a judgment under this section. So pay close attention. इस सेक्शन में 3 important चीजें हैं. First, lack of jurisdiction. In simple words, this means the court that gave the judgment didn't even have the legal power to hear that case. Second, fraud. This is when a party gets a favorable judgment by deceiving the court, maybe by hiding crucial facts or presenting false evidence. And third, collusion. This is when the two opposing parties secretly team up to get a judgment to deceive the court or a third person. So we've covered the theory, but how does this actually work in a courtroom? Let's make this crystal clear with a simple, practical example and then look at some very important case laws. All right, let's imagine a scenario. Party A files a case and gets a court decree for a piece of property. But here's the catch. A knew all along that there was a will which gave that same property to party B, and he deliberately hid this will from the court. So what happens when B finds out? Well, B can go to court and use Section 38 to challenge A's decree on the ground of fraud. Now for a couple of landmark cases you absolutely must remember. In SP Chengvalvaraya Naidu versus Jagannath, the Supreme Court made a powerful statement. A judgment obtained by fraud is a nullity. That means it's void from the very beginning, as if it never existed. And in Kiran Singh versus Chaman Paswan, the court held that a decree passed by a court that lacks jurisdiction is also a nullity. It has no legal effect whatsoever. These principles are fundamental. Now, for all of you preparing for your competitive exams, it's really important to know the context. How does this new section relate to the old law? Let's find out. So, here's the good news. This isn't a completely new rule. This provision used to be Section 44 of the old Indian Evidence Act of 1872. The new Bharatiya Sakshya Adhiniyam 2023 has kept the principle exactly the same. The grounds for challenge, fraud, collusion, and the court not being competent are identical. There's no major change in the substance of the law, it's just a renumbering. What was Section 44 is now Section 38. Okay, so let's focus on why this matters for you. This section is extremely important for both judiciary prelims and mains. For prelims, you could get a direct question on the section number. For mains, they want to ask you to explain its key ingredients. And for the APO exam, you can definitely expect a direct question asking on what grounds a judgment can be challenged, so you must know this section well. All right, before we wrap up, let's do a very quick revision of the main points to make sure everything is locked in your memory. So, to summarize everything, we discussed Section 38 of the Bharatiya Sakshya Adhiniyam 2023. The core concept is simple. It allows a relevant judgment to be challenged on 3 grounds: fraud, collusion, or lack of jurisdiction. And remember, it has very high relevance for both your judiciary and APO exams. For more judiciary-focused legal content, stay connected with Ganga Education.
Thank you for watching this session. If you found this lecture useful, do like, share and subscribe to Ganga Education. Keep learning, keep growing and stay connected for more law lectures.